All stand, please. You may be seated.
Thank you all very much. You can have a seat. State of Florida versus Eriese Tisdale, case 13-608. Mr. Tisdale's present. Mr. Glenn, Mr. Manship, Ms. Miranda, Ms. Celadonio are present here on his behalf. Mr. Backadal and Mr. Hendricks are here on behalf of the state. All right, Mr. Tisdale's case is set for sentencing this morning. Does the defense know of any other legal reason why he shouldn't be sentenced?
No, Your Honor.
State know of any legal reason why he shouldn't be sentenced?
No, sir.
Okay. Does the defense wish to make any other comment or present any other testimony prior to imposition of sentence?
Judge, if you could just give me a minute, please, till you stand on the line to speak.
Yes, ma'am.
Judge, I don't know if you, before we get to that point, there's no legal reason we cannot proceed to sentencing, but there are a couple of remarks I'd like to make relative to basically the posture of the case, just to kind of preserve a record on that. So whenever you want.
I'll give you a chance.
Okay.
I'll give everybody a chance.
Right.
I just wonder if there's any folks that want to say something prior.
Okay.
Yeah, Judge, I was anticipating the court was going to allow us
Sure.
to give our
yeah.
argument. Mr. Messenger.
Okay. Yeah, right here.
Do you want to come to the podium, Judge?
Morning. Tell me your name. Right here. Your name?
Vanessa Tyree.
What did you want to say, ma'am? Yes, ma'am. Take your time.
Good morning, Judge.
Morning, ma'am.
Judge, you already have heard about the life and the temperament of Eriese Tisdale. He is an intelligent and nonviolent young man who I know on that morning did not plan on killing anyone, and especially Sergeant Morales. I know that the law for premeditation states that even 3 to 5 minutes before a person kills another, that's premeditation. I didn't know that before I came to this courtroom, how many months ago. I do disagree on that. One definition that I've seen for that states premeditation, a premeditated crime involves careful planning. Unlike so many other mass murders that were planned weeks and months ahead of time, where the gunman has gotten up many guns and killed many, many, many people. This is not that case. Eriese did not wake up that morning and plan on killing anyone. No one did he plan on killing. He went to the store to buy some orange juice for his then-girlfriend, 7 months pregnant. He didn't break any laws going to the store, traffic-wise or anything, or leaving from that store that morning. But he was stopped by Sergeant Morales. I feel no one really knows what went on at that first stop, and that is unfortunate. There was no dash cams or anything that available. This has been a nightmare for our family, for the Morales family, for everyone involved. And I plead with the court for you to please give him no more than life. As I said, the premeditation, the law, it's a little bit too simple for me. I thought it was someone who had planned for weeks and months and did all this type of planning, involved planning, to kill someone. He did not. He woke up that morning, went to the store. And everything happened after that first stop with Sergeant Morales. And no one knows what happened. And I'm just going to say, this is my own belief. If Eriese did not have a gun in that car that day, he would have been dead instead of Morales.
Okay. Judge, we have nothing further from her.
Okay. Thank you, ma'am, very much. You can go ahead and have a seat. Thank you.
Ms. Eriese Tisdale.
Morning, Ms. Tisdale.
Good morning, Judge Vaughn.
What did you want to say?
We are here because of fear. Because of no dash cams, body cameras. If my son had been killed, Gary Morales would have been put on paid administrative leave, the outcome justified. Why? Because his position gives him the authority, the power to kill, not to injure and ask questions later. This conduct by officers has been going on around the country for years. There are a lot of great officers that go far beyond the call of duty. And Gary Morales probably was one of them also. Now with social media, cell phones, incidents are now being captured. Such cases as Trayvon Martin, Michael Brown, and now Corey Jones. And you ask the question, my son in fear for his life? No one wants to talk about the character or the demeanor of Mr. Morales. On February 28th, the way in which he approached my son is the reason why we're here today. My son, Eriese Tisdale, was in fear for his life. What happened on that day has forever changed both families, friends, co-workers, communities forever. Not only does my son deserve to live with this devastation and tragedy that we all are facing today, but this needs to set a platform so he can be an instrument to other young men of his experience, the do's and the don'ts, how to behave. He is a changed man. My son is not the same person that was arrested 3 years ago at the age of 25. Now 28, grown spiritually, mentally, and educationally. He has much to give back to community. He has much to give back to a correctional facility to be an instrument to help other young men to keep this type of situation from ever happening again or making them think twice of the outcome and what the future can hold for them. My son deserves a chance to be an inspiration to other young men as to the right choices to make in life so that this doesn't happen again. So I ask that the death penalty be put off the table and he's given a chance to rectify. We cannot bring Sergeant Morales back, but to use this situation to help other young men in the community are devastated by things that has happened in the past with officers. And like I said, there's a lot of great officers, and Gary Morales probably was one of them also. Thank you.
Thank you, Ms. Tisdale.
I believe that's all.
Back to Lenny.
Judge, I'm
Rouse.
grateful for the opportunity that you've given us today to call family members and friends of Gary Morales. I've had an opportunity to discuss with those folks, and they've indicated that they don't wish to offer any additional comments outside of what they offered during the course of the trial and, of course, the victim impact. But I would like to make just a statement at this time, if it's appropriate.
Give me a minute. I'll give you a chance just a minute.
Your Honor,
Yes, ma'am.
before you go forward, Eric has decided that he would like to say a few words.
Okay, I'll give everybody a chance in just a minute.
Oh, I'm
I will
sorry,
give everybody a
about
chance in
20
just a minute.
seconds.
If you'll bear with me just a minute. A couple of preliminary things I want to clear up before we proceed. By my calculation, Mr. Tisdale is entitled to 1,156 days credit time served as of today's date. Does that sound accurate to the defense?
Yes, sir.
Okay. State.
No objection.
All right. Ms. Saldonio, what fees or costs are y'all asking be imposed?
I apologize, Your Honor. I left that on my desk.
Okay, and I'll just reserve jurisdiction on that. How about the state? Are y'all seeking assessment of any?
Your Honor, yes, the state of Florida requesting the statutory fee of $100 for cost of prosecution.
Defense have any objection to that being assessed as a
No, Your
civil
Honor.
judgment? Okay. All right, now before we go any further, let me just ask all of you all in here to please be quiet. Please be quiet. Please be quiet. Please. If you would please turn off your cell phones or turn them on silent, please. Please show respect and courtesy to the attorneys here this morning, to the Tisdale and Morales family members, and to the defendant. I don't want any gestures being made. I don't want any comments being made unless I ask for them, or inappropriate behavior in here, please. I think y'all can understand why. Before I go any further and I forget, let me just publicly, I want to thank all the attorneys involved in this proceeding on both sides, the state and the defense. They have been very diligent, prepared, thorough, and professional. I appreciate the cooperation they've shown each other to the extent they can, of course, and the cooperation they've shown me. Also, I would be remiss if I didn't also thank my deputy clerks over here on my right and y'all's left, and the court security personnel during this proceeding. So, with that in mind, thank you. Now, Ms. Celedonio, is there any other? Mr. Tisdale wishes to comment?
Yes, Your Honor, yes.
Sir, you're fine right there. If you just want to stand up and say what you wish to say.
I want to say that just as no man can weigh the heart of another man, my future lies not in man's hands, but in God's hands, the creator of all mankind. Just as no man can put his passion inside another man, no man can judge me with true weight as the so-called justice that's supposed to be done today. So I know that no matter what will happen, my future will always be in God's hands. And no matter what, one day I will walk free, and that is by the grace of God. And it's through the true justice, which is justice is a gift to all mankind, which is freedom, forgiveness, and faith. Therefore, I know that that is the reason why I'm still alive today, and that is the reason why I have a voice to speak to all of the young men who don't have a voice to speak, whose parents are still grieving and have no reason to know why, have no understanding of why their son or their daughters have passed away by the hands of so-called justice. Therefore, when I walk free, I will be a voice to all the young men who have no voice, all the young men who have no understanding of why they can walk the street and be harassed for no reason at all. These same laws are the same laws that said a man cannot walk free without a slave walking free pass, and had justice to be put on them for being a free man back in the 1800s, 1890s. These are the same laws that this man here is trying to put on me today to tell me as a man what rights I have as a man. So therefore, I want to say also to the Morales family that I am truly regretful to be responsible for the pain that they have today, because man is made in God's image, and a man is someone who is supposed to be the carrier and the protector for their family. So I can understand what kind of hurt that will end to that family. And I want to say that I am truly sorry and I'm truly regretful as a man to be able to sit here in this position to be the man with the finger pointed at to be responsible for this situation. But I want to say that no man was there to know my heart. No man was there to know what I had in my eyes and the feeling that I had in my chest on February 28, 2013. So therefore, I just want to say that I ask that something changes about the law, because there is no balance to this law. When one man, because of the color of his uniform, can walk free without no repercussions for killing a man, shooting a man in his back, shooting a man as he tries to get away, there has to be some kind of law That's what I ask. No matter what my future holds, there's some kind of law that can balance. Just as there are aggravating factors to make a man who is convicted of killing a law enforcement officer, there should be aggravating factors for a law enforcement officer who kills a harmless young teenager to balance this weight. Other than that, there will be a perpetual cycle of violence because man cannot estimate what reactions a young man will have towards someone who carries a badge and a gun. So I do want to say to all the young men out there on the streets to follow peace and see your next man not as a man but as yourself, not as the opposite man but as yourself. Whether they're police or whether they're a person on the street, or whether you're a police, don't see a criminal as a criminal, see him as yourself, because he has the same blood and breathes the same air that you do. And that's all I have to say. And God bless everybody, and I just hope that everything works out for the better. Thank you.
Thank you. Celedonio, anything you all wish to say on his behalf?
Judge, we do have the cost. It's $109,135.35 cost for the public defender's office.
109-135-35.
Yes, sir.
Mr. Tisdale, the defense is requesting a fee be imposed for their representation costs in this case of $109,135.35. You have the right to have a hearing on that if you wish to determine if that's a reasonable amount, or you can waive or give up that right, and I'll impose that as a civil judgment without any further court hearing. Do you understand that? Do you wish to have a hearing on it, sir, or do you not wish to? I'm sorry?
No.
No hearing, sir?
No hearing.
All right. Does the defense wish to make any other comment?
Judge, is this where you would like us to make?
Yes, ma'am.
Judge, as Eric and the defense team stands before you in your preparation to sentence him, the two choices before the court from the beginning of this case has been due to a capital charge in this offense, first-degree murder. Eric has been charged and found guilty. Life and death has always been on the table, but now since we have gone through the phases of a capital case, we just want to ourselves discuss a little bit about the posture of this case from the onset. Capital cases are obviously the highest charge that a person can be charged and be sentenced to. That being said, capital cases are specifically enumerated in the statute book and specifically have their own set of rules to abide by and for the court to follow and the procedures. We often hear the sign, the words and the slogan, death is different. Well, death is different because it requires very specific findings by juries, by the court, in order to impose a sentence of death upon the person that was convicted of first-degree murder. In addressing those requirements, this case came at a point in time, although it's been known for years and decades that, people have been fighting to abolish the death penalty. What we have here today is a case that was brought before the court in a posture in which the Supreme Court ruled in the Hearst case that change needed to be made by finding the sentencing scheme unconstitutional on February 12, 2016, and making that finding puts this case in a very different posture than any other case based on that ruling. We have already been through the guilt phase in October, the penalty phase. We were left with the sentencing phase, the sentencing of Mr. Tisdale. As we've always known, there was two phases to this case because death was always on the table. In the guilt phase, the determination of whether or not we go to a second phase, the penalty phase, had to be determined by a unanimous vote by the jury of first-degree murder. If that was not the case, we would not have gone to a penalty phase. So in order for the jury to get to sit on a penalty phase, to make the determination of eligibility for death, or to make the recommendation for death or life in their verdict in the penalty phase, they would have had to have found a unanimous verdict in the first phase that we call the guilt phase. That was done in this case. What makes this case a little bit more unique than all the other cases that we've been reviewing and discussing about since the first decision is the fact that this particular case involves the death of a law enforcement officer. Now, at the beginning of this case, the instructions that were given to this jury that we impaneled and that we went through a week-long process of what we call getting them death qualified to sit on the penalty phase and the guilt phase. We instructed them that there would be two phases. If they were to find Mr. Tisdale guilty of first-degree murder, then it would go to a second phase. They were instructed time and time again that they were to keep the penalty phase and the guilt phase separate, although we needed to address these issues in the jury selection process. This jury that we qualified and sat on the guilt phase heard the evidence and the facts presented to them based on state having to prove beyond a reasonable doubt to them, and for them to make a verdict of unanimity for first-degree murder to go forward to the second phase. That happened. If it didn't happen, we wouldn't have went to the second phase. So we went to the second phase because that was the case. It is at that second phase that the statute is clear that the mitigation must be weighed against the aggravating factors. But the first thing that has to happen is the aggravating factors have to be presented by the state. Now that seems to be the hot topic as to where the court has been left to decide whether or not death is still a viable sentence in this case. But the weighing factors in the penalty phase is still something that has to be considered by the jury. The Hearst decision said that the court can no longer be the finding of fact for the eligibility of death. It has to be left to the jury. This jury, although they found unanimous in the guilt phase, there is no exception in the law that because it was a law enforcement officer, that the aggravating factors are in the indictment, that therefore you don't go to a penalty phase to do the weighing to make the determination of eligibility. It's a two-part process. So for the court to decide the fact-finding based on the aggravators that were essentially proven in the guilt phase, and to carry over the logic of this jury that was advised that their verdict had to be unanimous in the guilt phase, and to use the rationale that the aggravators were in fact in the indictment, and to make its own fact-finding as to the interpretation as to what this jury was deciding on the penalty phase, when their verdict in the penalty phase, after weighing the aggravators and the mitigators, was 9-3, goes against logic. So this court is our position that cannot just rely on the fact-finding to find a guilt verdict and roll that over to band-aid the Hearst decision that said it's unconstitutional, the sentencing scheme. That's where the defense advises the court in our own research and finding that the court, if it were to apply the law that was in existence at the time of our trial in sentencing phase, you have to sever the death scheme and the sentencing that was found unconstitutional. That the court is only left with our particular case with a life sentence, as the statute dictates. When the death scheme, when something's found unconstitutional, the death scheme was found unconstitutional. So under Furman, you must sever it. And if you sever it, the law that was before the court is left with a life sentence. If this court were to want to go on the rationale that the new law that was decided on March 7, 2016, is the appropriate amended statute to sentence Mr. Tisdale on, this court would have to go through the entire weighing of the aggravators and mitigators, but once again, this jury, what they were instructed on was advisory. However, their jury did not come back with a unanimous verdict in the penalty phase. They came back with a 9-3. And if this court were to apply the new amended statutes, then the court would have to be bound by that jury's recommendation of 9-3. The new law clearly states that it is out of the discretion of the court to sentence to death if the jury's recommendation is not at least 10-2. And so, in applying the new law, if the court were to go in that direction, Mr. Tisdale's sentence would need to be a life sentence as well. So the defense is humbly and respectfully requesting this court to follow the law to sentence Mr. Tisdale in the manner in which the court was left, with this case going forward to trial in the penalty phase, and then the change of the law and the Hearst decision coming in the middle of it before sentencing. We believe that the retroactivity was not specifically expressed, so the new law we do not believe applies. However, this court wants to go forward. A life sentence is the only sentence the court can give, because it can't pick and choose what portions of this new statute it would adhere to the facts of this case and which ones it would not. And in order for the court to go back and sentence to Mr. Tisdale, knowing that Hearst was decided, knowing that the law and the legislature has gone forward to change the statute, for this court to disregard that and to not follow the precedents in Furman for the severability, and to just pick and choose the factual finding of a jury that we advised were not instructed that they were only advisory, would go against the legislative intent, and we would ask the court to sentence Mr. Tisdale today to a life sentence, which we believe is the only constitutional sentence that he can receive at this point.
Thank you very much. Back it up.
Hey, please, the court. Judge, you find yourself in a very difficult situation today in terms of guidance upon which we normally would rely, as we expect finality and consistency. First of all, on behalf of the people of the state of Florida, I thank you for your patience and the opportunity to give the parties to address this matter and to brief it. And I think both sides did a commendable job in addressing all of the issues for the court's consideration. And I think now, as you kind of reflect on our relative positions, you've got 3 choices. And each of those choices will have a consequence. And of those 3 choices, the consequence of 2 of them will be final here today. Your first choice, as the defense has asked, they've asked that you sentence the defendant to life in prison without the possibility of parole. Everybody in this room knows that if that is the sentence this court imposes, that will be the sentence. We know that the state will have no effective appellate rights. The state will not be able to call into question the court's ultimate sentence, because you will have judged that that's the appropriate sentence, and that will be that. And so, if you're wrong, and I mean this with all due respect because it's a difficult position, but if you're wrong, the state is done. Your second choice is, as you had indicated in your request for an expedited briefing, was what about a do-over, if you will? Impanel a second penalty phase, proceed, obtain a recommendation. There are a couple issues with that. The first issue is neither of the parties are requesting that. The second issue is the defense position is that the new statute is substantive in nature, and that as a result of the present state of the law, as well as provisions within the Florida Constitution, you are legally prohibited from retroactively applying the new statute. I don't think I necessarily agree with that argument. In fact, I don't agree legally with that argument. I think it doesn't apply for a different reason. I think it doesn't apply because the statute in effect at the time, given the unique posture of this case, indicates it doesn't apply. That is to say, we weren't between guilt and penalty phase. We weren't even halfway through the penalty phase. We were through the penalty phase. We had a valid recommendation, and we had completed a Spencer hearing, and we were 2 days or so from sentencing. So I say to you the consequence of throwing out this particular recommendation from the jury and starting again. Well, I must say to you, I have no faith in this system. I have no faith in this regard. The rules constantly change. And so now, if you were to take that action, it is eminently conceivable to me that some sharp criminal defense lawyer, appellate lawyer, will take the position, wait a minute, he was placed in jeopardy in the initial penalty phase. There was a full proceeding. The court should not have granted a new trial or new penalty phase, and jeopardy attaches. I don't know. Or some due process, some vacuous due process argument. This defendant's life was placed before a jury in a penalty phase, what have you. And if that argument works, then inevitably what will happen is a life sentence will be imposed. And again, they'll be denied justice. So that leaves you your final choice. And it is death. And this case from day one till today, despite his comments, is a death penalty case. It warrants death. Justice demands death in this case. Now, if you engage in the process, as is outlined in the statute in existence at the time, and you render an order relying upon the aggravators as proven, beyond a reasonable doubt, found unanimously by the jury, they will not execute him on the bus ride to Rayford. He will go to prison, he will sit on death row, and he will have all of the vast resources of the capital conflict or the capital attorney's litigation skills to appeal this matter to the Florida Supreme Court. And then if you're wrong, because you follow the state's advice, one of two things will happen. They'll say, send it back and do it again, and then we'll know, we'll have some guidance, because that's how this is supposed to work. Or they'll say you're wrong and you have to impose life. Either way, it's no harm, no foul. Justice demanded. So here's the big confusion, and I think the defense's confusion with respect to everything that has happened post-Hearst. Basically, first I refer to Judge Perianti. The fact of the matter is, the record reflects Judge Perianti basically had this right from the beginning. What she said and what Hearst quoted, what Sotomayor quoted Justice Parente as saying in Hearst is, at page 4 of that slip opinion, she said, Justice Perianti, joined by her two colleagues on the Ring issue, dissented from that portion of the opinion, and she reiterated her view that Ring requires any fact that qualifies. Judge, words have meaning. That is a significant term Judge Perianti used. Qualifies a capital defendant for a sentence of death to be found by the jury. Now we all know Judge Perianti and her colleagues had it right, according to the United States Supreme Court. So it is this eligibility selection distinction that is at the very heart of this case here today. Eligibility, and the problem with the defense is they're melding the two. Eligibility is merely a reiteration of what the court has said from Apprende through Ring through Hearst, which is simply to say a condition predicate. A condition to seeking the death penalty is two things. As Ms. Salodonia pointed out, you've got to have your guilty verdict of first-degree murder, because we don't execute for anything else in this country. And number two, you must have a finding by the jury of the existence of an aggravator, which then makes the defendant eligible. That is the sole and exclusively required constitutional action that a jury must take. as it relates to the selection phase, what Ms. Saldonia says to you and what she artfully argued in all of her responses to the court is, look, Florida is a weighing state, and therefore the jury is engaging in this weighing process, and it is that weighing process that is required to be somehow recorded in a verdict. It's impossible, and it's not consistent with the present state of the constitutional law. And what I cited to you, I think the most important section within my brief is where I started off discussing the eligibility selection process. And I'm going to butcher the name, but it's Tulipia versus California. And of course, they point out, and what's more significant is, 2 weeks after Hearst, or several days after Hearst, the United States Supreme Court issued another opinion in which they confirmed this eligibility selection issue. So these are viable constitutional arguments immediately today. They discuss eligibility, we've talked about this. But selection is, at this stage, the state's not confined to submitting specific questions to a juror, nor need they even be instructed on how to weigh those factors. And I think Scalia makes a really good point in Kansas v. Carr, where he says, how would we ever tell a jury to weigh? How do you instruct a jury you must weigh these mitigating factors, such as, I'm a black man in America? You can't instruct them what kind of weight they can give to it, and if you can't instruct them, how would they ever record it? Would they say, we think it's entitled to a little bit of weight? And each and every individual juror is going to have their own feelings about that. And so what the court has said, and the court has consistently said, is there isn't even a constitutional requirement that we get an advisory sentence from the jury. The Sixth Amendment requires that you qualify or make the defendant eligible for death. But the weighing process that a jury engages in is a procedural mechanism that we have created because I guess it makes us feel more comfortable that we put that issue into the hands of our fellow citizens. What Scalia said about this selection phase of a capital proceeding is that it's basically judgment calls. And you can't expect to have a fact-finding on a judgment call. You cannot have a specific finding of fact that would relate to something that is a judgment call. So in the end, the court, I think in your last email to us, asking that last question is where you hit the nail on the head. And what you said is, this court asked whether Hearst, Ring, or Apprendi, where does it say that a guilt phase finding by the jury is not sufficient enough to make the defendant eligible for the death penalty? And does this finding by the jury then comply with Hearst, Ring, and Apprendi? And I said yes. And so you go back to Apprendi. And Apprendi told you, and has said from the very beginning, that a jury finding, whether it's in the guilt phase, whether it's admitted to by the defendant as well, incidentally, is sufficient to allow the court to enhance a sentence. We used to call them sentencing enhancers, now they're elements. So a jury finding of fact of an aggravator would have satisfied Ring. And then at the end of the day, from Apprendi through Ring, through Hearst, the courts have told us you may engage in a harmful error analysis. And what I say to you is there is no error in this record. It is error-free because there is an actual finding. Now, procedurally, we did not have a mechanism in place where we said you must check a box in the penalty phase that you find Gary Morales was a law enforcement officer, a fact they did find beyond a reasonable doubt after being instructed in the verdict, and a fact which the defense did not dispute. That's the procedural error. But if it was error, and if it was error, it clearly had to be harmless in the light of the fact that we have these findings in the record. And with that in mind, then, the defendant becomes eligible. You have a recommendation, which under the old statute, you're free to disregard. You may, for all I know, you may engage the old statute, you may weigh the aggravators and the mitigators and conclude that the mitigation presented by the defense outweighs the aggravators, and you would impose a life sentence, and that would be lawful. Because that's the statute that applies due to the posture of this case, which is exceedingly rare and unique. And so we're asking you to engage in that process. So my legal argument, that's my legal argument. I have a concluding, just brief statement I'd like to make whenever you want. If you prefer, I do it now.
Now, if you wish.
And it's a statement for the family, and it is, I'm sorry. I'm sorry on behalf of a broken and dysfunctional criminal justice in Holly, Mr. and Mrs. Morales. the family and friends and loved ones of Gary Morales. 3 years ago, almost to the day, you came into my office, remember? And you sat down with me and Bruce Colton, and we sat around a big table. And this is what I said to them, Judge. I said, here's how it works, didn't I? It's going to be a long haul. It's going to be difficult. But here's how the system works. And I could say that to them. It's the only thing I could promise them. I couldn't promise an outcome. I couldn't promise a duration. But I could promise how the system works. Because the system is based upon finality. Right? The whole theory is the court issues opinions upon which we act and rely in this courtroom, in this criminal justice system. And for almost over 4 decades, the courts in Florida and the United States Supreme Court have had a very specific set of rules that I told them would apply. And now they've suffered additional pain and agony as a result of a 10-page, hastily drafted opinion which provides Your Honor and the Florida Supreme Court with virtually no guidance. And with the sweep of a pen, they dismiss over 40 years of jurisprudence in the capital scheme without one whit of concern or thought for the impact it would have on them. And for that, I'm sorry. On behalf of myself and the people. Thank you, Judge.
Now, there's also case 13752, which remains pending. I don't know if y'all wish to have that set for trial or what. Before we conclude, I want to address that.
Yes, sir, we'd like to set for trial.
Okay, stay ready for trial in that case?
Yes, sir.
Okay, I'll have to find a date to set it since I'm in Okeechobee now and not over here. So, okay, I'll set it for trial and I'll send y'all a notice of a trial date.
Judge, are you going to allow us to rebuttal
If you wish.
to address? Thank you, Judge. Court. Judge, the state in this case has told you that if you err, there is no harm and no foul. And I completely and totally disagree with that statement, Your Honor. The state says that they no longer have faith in our system. Judge, I also disagree completely and totally with that statement. I have faith in our system. I have faith in our system. That we have a judicial system where important decisions are given to judges to make. In this case, when we started, we knew Hearst was out there. We discussed in our pretrial pleadings the coming of Hearst, that the Supreme Court was going to hear Hearst, and what the arguments would be since we had those pleadings to avail ourselves to. And in fact, Hearst did come. And in this particular case, Judge, be it the universe, be it whatever it may be, it came 2 days before our scheduled sentencing. And I think it was very wise of this court to take time after Hearst decided and not rush into judgment without being fully appraised of what the different sides of this opinion meant. And so, Judge, I would refer back to both the state's and our supplemental sentencing memos which address the Hearst opinion. And clearly, we have very different opinions of what Hearst means in this case. We truly believe that under the Sixth Amendment, that the fact-finding must be done by the jury. And as Ms. Celedonio pointed out earlier, the fact-finding does not end on the guilt phase. That is why there is a penalty phase. And during the penalty phase, the jury does additional fact-finding. And I think what makes it so clear in this case is the fact that the jury's recommendation was by a vote of 9-3, and not a unanimous decision to recommend to this court. And the reason that that's so important, Judge, is because the jury, when they were back there considering all of the mitigation and the aggravators in this case, they already had decided the guilt. And they all knew that they had unanimously decided that. And yet, three people back there voted for life. And so what that tells us, Judge, is that three people did not find that the aggravators outweighed the mitigators. Had it been a unanimous 12-0 recommendation, we would be in a very different posture, Your Honor. But we're not. And we're not because three people recommended life in this case. Therefore, those three people, Judge, did not find the aggravators beyond a reasonable doubt, or that the mitigators outweighed them. And I mean, logic tells us. And we can look back, and we can say, well, let's think about what the jurors must have meant when they chose 9-3. What did those three jurors, what were they thinking? Why did they come to this decision? There is a way for us to know, Judge. There are questionnaires that we can send back with jurors. There's this whole procedure. But the bottom line is that weighing is a fact-finding. It's not simply a judgment call. It is, and I would put this forth to the court, it is an element. Because once eligibility is determined, the only way a greater punishment can be declared is once that weighing is done. We ask jurors all the time to weigh things, Judge. In every trial in this courthouse, we ask jurors to weigh the facts against what they've heard, against the posture of a witness. We ask them to weigh all the time. And this is one additional element, if you will, that they must weigh in order to allow for the additional punishment of death. Judge, I don't envy your position. I know there's not a lot of guidance out there for you. But I would tell you this. The beauty of our Constitution and the history of our Constitution says that if we are to err, we should always err on the side of the individual. If it's too close to call, our error should not just no harm, no foul, let the appellate courts decide it. No, Judge. That's not the way of our Constitution. That's not the way of our judicial system. The way our rules, which have been handed down to us from the makers of the Constitution, is to protect the individual. That's why burden of proof in criminal cases is beyond a reasonable doubt. That's why in the penalty phase we tell jurors aggravators must be found beyond a reasonable doubt, but mitigators only need be found by a preponderance of the evidence. Why that difference? Well, clearly it's because in our judicial system, Judge, we must protect the individual. And I ask, in this case, and I know you're going forward without any guidance, Judge, but I ask you to consider that. And consider that if this court were to err, let it err on the side of the individual. And I believe you will be on the right side of history. And I ask this court to sentence Eriese Tisdale to the only legal and just sentence in this case, and that is life in prison without the possibility of parole. Thank you, Judge.
Thank you, Ms. Miranda. Mr. Tisdale, the jury, having found you guilty of first-degree murder with a firearm of Sergeant Morales, who was engaged in the lawful performance of his legal duties, In count 1 of the indictment, guilty of aggravated assault on a law enforcement officer while possessing a firearm as alleged in count 2 of the indictment, guilty of possession of firearm by a convicted felon as alleged in count 3 of the indictment, and guilty of fleeing and eluding with lights and sirens as alleged in count 4 of the indictment. I'll adjudicate you guilty of each of those offenses. Florida law requires you be fingerprinted here in open court, so if you'll step over here, please, and be fingerprinted as required by law. Tisdale has been fingerprinted in my presence in open court as required by law. All right, thank you all for your comments. And again, I appreciate the lawyer's work in this case, y'all's thoroughness, your diligence, your preparation, your patience with me. It deserves to be mentioned again. So I appreciate that very much, and y'all's thoroughness in the memorandum. Now, certainly, I am aware of the significance of this case. I am aware of the significance of this case. I am aware of the significance of this case to the state, the defense, and both the Morales and Tisdale families. Ordinarily, from the education I've received, it suggests that the court, in pronouncing sentence, simply file the sentencing order with the clerk and pronounce sentence. The education I've received says reading an order such as this is not necessary. I choose not to just simply file it with the clerk and pronounce sentence. Certainly, I'm required by law to contemporaneously file the order once sentence is pronounced, and of course I'll do that. I have the order here. I have each of y'all copies, which I'll provide to you when we conclude. I will read the entire order. It is lengthy. Bear with me while I do so. So please understand and bear with me while I read it in its entirety. I certainly am not reading it simply because I just want to sit here and hear myself talk. Rather, I want both the state and the defense and the public to know why I've reached my conclusions. Of course, this order will be filed with the clerk and will be a part of the court record and public record for public inspection at the conclusion of the case. But under these circumstances, I think it's necessary and incumbent on me to read it. So, if y'all would mind, be patient with me and bear with me while I read this and refer to certain portions of the Hearst decision and others while I go through this. And again, please don't interrupt me. I don't want anybody making any gestures or comments or acting inappropriately while I do this, please. Eriese Alfonso Tisdale, you are now before this court for pronouncement of sentence You have been found guilty by the jury of first-degree murder with a firearm of Sergeant Gary Morales, who was engaged in the lawful performance of his legal duties as alleged in count 1 of the indictment. Guilty of aggravated assault on a law enforcement officer while possessing a firearm as alleged in count 2. Guilty of possession of firearm by a convicted felon as alleged in count 3. And guilty of fleeing and eluding with lights and sirens as alleged in count 4. The guilt phase of the trial ended on October 1st, 2015, when the verdict was rendered by the jury. Following the guilty verdict, the court and the jury heard additional evidence and argument from the state and the defense pursuant to the applicable Florida law in effect at the time in the penalty phase. On October 9, 2015, the jury recommended by a vote of 9-3 that the death sentence should be imposed by this court on count 1, first-degree murder of a law enforcement officer while engaged in the lawful performance of his legal duties. On November 17, 2015, the state and the defense were permitted to present additional evidence and argument to this court at the Spencer hearing, pursuant to Spencer v. State 615 Southern 2nd 688 and Phillips v. State 705 Southern 2nd 1320. Now, unless otherwise indicated, all of these cases are Florida Supreme Court decisions. Subsequent to the Spencer hearing, the state and the defense submitted separate sentencing memoranda on November 12, 2015 by the state and December 1, 2015 by the defense, with the state's final response filed on December 8, 2015. This is pursuant to Consalvo v. State 697 Southern 2nd 805, Hodges v. State 595 Southern 2nd 929, which was reversed on other grounds, Hodges v. State 113 Supreme Court of the United States 1992, Lucas v. State 568 Southern 2nd 18. The final sentencing hearing was set for January 15, 2016. This trial and sentencing procedure had been approved in Spezzano v. Florida 468 U.S. 447 in 1984 and Hildwin v. State 490 U.S. 638 1989 by the United States Supreme Court. This court has carefully heard and considered the evidence presented at the Spencer hearing and has had the benefit of the sentencing memoranda from both the state and the defense, which this court has thoroughly considered pursuant to Phillips. The final determination of the appropriate sentence rests solely with this court. This order has been personally prepared by this court, pursuant to Blackwelder v. State 851 Southern 2nd 650, Valley v. State 778 Southern 2nd 960, Spencer v. State 625 Southern 2nd 688, Card v. State 652 Southern 2nd 344, Richardson v. State 437 Southern 2nd 1091, Smith v. State 515 Southern 2nd 182, and Jackson v. State 648 Southern 2nd 85. This court must make its own independent evaluation of the aggravating and mitigating factors proven in this case, pursuant to Florida Statute 921.141 paragraph 3 in writing, pursuant to Grossman v. State 525 Southern 2nd 833 and Perez v. State 648 Southern 2nd 715. Prior to the January 15, 2016 sentencing date, this court began personally preparing the factual findings and a sentencing order as required by Florida law. Richardson v. State 437 Southern 2nd 1091. This court also gave great weight to the jury decision. 3 days prior to the imposition of the sentence in this case, the U.S. Supreme Court rendered its opinion that the death penalty was unconstitutional. This opinion specifically overruled or vacated at least 2 prior U.S. Supreme Court cases dating as far back as 1984 in Spezzano, which approved the applicable Florida statutory scheme. In light of the Hearst decision, this court postponed the sentencing in this case and again requested memoranda from both the state and the defense in order to determine the appropriate way to proceed given the procedural status of this case. That is, the defendant had been found guilty as charged in the indictment. The court had received a jury recommendation as referenced above, but the defendant had not been sentenced. The state and defense were kind enough to submit very thorough, well-researched memos detailing their respective positions. Of course, the court carefully considered both. This court has participated in and presided over a number of death penalty cases. In addition, this court has attended numerous educational courses in handling capital cases offered by the Florida Conference of Circuit Judges and other organizations. This court has reviewed a voluminous amount of related written materials on the Florida death penalty scheme. Consequently, this court is very familiar with Florida law and the evolution of other cases decided by the U.S. Supreme Court with regard to the issues presented in this case. To summarize, this court is familiar with Apprendi v. New Jersey, 520 U.S. 466, Ring v. Arizona, 536 U.S. 584, and now Hurst v. State, 136 Supreme Court 616, all United States Supreme Court cases. I have read the Hurst decision at least 30 times. I have read the state and the defense memoranda at least that many times. The Hurst decision is very short by U.S. Supreme Court standards. It totals 16 pages, including the concurring decision by Justice Breyer and the dissent by Justice Alito. In order to be thorough in this matter, and so the public and the courts will know why this court came to its conclusions, this court will now read the relevant portions of the Hurst decision here in open court. And portions of relevant parts of both the state and defense memorandum. By doing so, this will inform the parties and the public what the current state of the law is now and help explain the court's interpretation of these as they apply to the facts presented in Mr. Tisdale's case. In Hurst, the court held Florida's capital sentencing scheme violates the Sixth Amendment in light of Ring. The court wrote, any fact that, quote, exposes the defendant to a greater punishment than that authorized by the jury's guilty verdict is an element that must be submitted to a jury, citing Apprendi. Applying Apprendi to the capital punishment context, the Ring court had little difficulty concluding that an Arizona judge's independent fact-finding exposed Ring to a punishment greater than the jury's guilty verdict authorized. Ring's analysis applies equally here. Florida requires not the jury, but a judge to make the critical findings necessary to impose the death penalty. In the body of the opinion, Justice Sotomayor wrote, we hold this sentencing scheme unconstitutional. The Sixth Amendment requires a jury, not a judge, to find each fact necessary to impose a sentence of death. A jury's mere recommendation is not enough. They refer to the Hurst decision. At the close of the Hurst offense, the court wrote, the judge instructed the jury that it could find Hurst guilty of first-degree murder under two theories: premeditated murder or felony murder for an unlawful killing during a robbery. The jury convicted Hurst of first-degree murder, but did not specify which theory it believed. The court went on to describe the procedure that was followed in Hurst as it was here. Following this procedure, Hurst's jury recommended a death sentence. The judge independently agreed. It went on to a resentencing. At the resentencing, the sentencing judge conducted a new hearing which Hurst offered mitigating evidence that he was not, quote, a major participant in the murder because he was at home when it happened. The sentencing judge instructed the advisory jury that it could recommend a death sentence if it found at least one aggravating circumstance beyond a reasonable doubt. That is, that the murder was especially heinous, atrocious, or cruel, or that it occurred while Hurst was committing a robbery. The jury recommended death by a vote of 7-5. The Supreme Court wrote, the sentencing judge then sentenced Hurst to death. In her written order, the judge based the sentence in part on her independent determination that both the heinous murder and the robbery aggravators existed. The Florida Supreme Court affirmed that. The court went on to write, in Apprendi v. New Jersey, 530 U.S. 466, this court, the U.S. Supreme Court, held that any fact that exposes the defendant to a greater punishment than that authorized by the jury's guilty verdict is an element that must be submitted to a jury. They went on to write, in Ring, we concluded that Arizona's capital sentencing scheme violated Apprendi's rule because the state allowed a judge to find the facts necessary to sentence a defendant to death. Specifically, a judge could sentence Ring to death only after independently finding at least one aggravating circumstance. Ring's judge followed this procedure, found an aggravating circumstance, and sentenced Ring to death. The U.S. Supreme Court wrote, the court had little difficulty concluding that the required finding of an aggravated circumstance exposed Ring to a greater punishment than that authorized by the jury's guilty verdict. Had Ring's judge not engaged in a fact-finding, Ring would have received a life sentence. Ring's death sentence therefore violated his right to have a jury find the facts behind his punishment. The analysis the Ring Court applies to Arizona's sentencing scheme applies equally to Florida's. As with Timothy Ring, the maximum punishment Timothy Hurst could have received without any judge-made findings was life in prison without parole. As with Ring, a judge increased Hurst's authorized punishment based on her own fact-finding. In light of Ring, we hold that Hurst's sentence violates the Sixth Amendment. The court went on to write, time and subsequent cases have washed away the logic of Spezzano and Hildwin. The decisions are overruled to the extent they allow a sentencing judge to find an aggravating circumstance, independent of a jury's fact-finding, that is necessary for the imposition of the death penalty. The court concluded the Sixth Amendment protects a defendant's right to an impartial jury. This right required Florida to base Timothy Hurst's death sentence on a jury's verdict, not a judge's fact-finding. Florida's sentencing scheme, which required the judge alone to find the existence of an aggravating circumstance, is therefore unconstitutional. Procedurally, of course, because of the Hurst case, only two potential aggravating factors now survive. That is, the first-degree murder of a law enforcement officer while engaged in the lawful execution of his legal duty as alleged in Count 1, and the contemporaneous conviction of aggravated assault on a law enforcement officer while possessing a firearm as alleged in Count 2. The other aggravating factors argued by the state at trial, that is, the capital felony was committed for purpose of avoiding or preventing a lawful arrest or effectuating an escape from custody pursuant to Florida Statute 921.1415C. The capital felony was committed to disrupt or hinder the lawful exercise of any governmental function or the enforcement of law pursuant to Florida Statute 921.1415A are no longer viable aggravating factors for the state to argue or the court to consider in light of Hurst. This is so because those factors were part of the unconstitutional process, as no jury found these specifically proven beyond a reasonable doubt, nor was it reflected in the verdict. The state properly concedes this point. As referenced earlier, the jury found, not the court, beyond a reasonable doubt that a defendant was guilty of Count 1, first-degree murder of a law enforcement officer while engaged in the lawful execution of his legal duty, and Count 2, aggravated assault on a law enforcement officer while possessing a firearm. Both of these are statutory enumerated aggravating circumstances under Florida Statute 921.1415J and Florida Statute 921.1415B, respectively. The state argues that because these two surviving factors referenced above were found to exist beyond a reasonable doubt by the jury in the guilt phase, and therefore this jury finding complies with the Apprendi, Ring, and Hurst requirements, and consequently this defendant remains eligible for the death penalty. The defense objects, arguing the only lawful sentence a court can now impose is life in prison without parole. Neither party seeks a de novo resentencing proceeding pursuant to the new procedure enacted by the legislature and signed by the governor. It is an undeniable fact this defendant was found guilty by a reasonable doubt, beyond a reasonable doubt, by the jury, not the court, of first-degree murder of a law enforcement officer while in the performance of his legal duties, and guilty beyond a reasonable doubt of aggravated assault on a law enforcement officer with a firearm. As referenced earlier, both of these convictions qualify under Florida law as statutory enumerated aggravating factors. This also is simply undeniable. Because the aggravating factors the state proposed were not found to exist beyond a reasonable doubt by the jury, that evidence is not being considered by this court. In the Hearst case, which used the same statutory procedure this court used, the facts showed in that case the female victim was brutally and repeatedly stabbed over 60 times and was robbed. Hearst at page 1. The aggravating factors found to exist by the trial court, not the jury, in that case were the homicide was a heinous, atrocious, and cruel homicide pursuant to Florida Statute 921.1415H, and a robbery was committed. Certainly the jury did not find the homicide was heinous, atrocious, and cruel, and Hearst was not convicted of robbery in that case by the jury beyond a reasonable doubt, and certainly this was not reflected in the jury's verdict form. In this case, Mr. Tisdale, under the unique facts of this case, was found guilty beyond a reasonable doubt of the two referenced statutory aggravating factors. These charges were clearly alleged in the indictment and were clearly reflected in the jury's verdict. Consequently, these findings by the jury, not the court, comply with the Prendy, Ring, and now the Hearst line of cases. This is so because the jury, not the court, has found beyond a reasonable doubt from the evidence the defendant guilty of two aggravating factors that would expose this defendant to greater punishment than that authorized by law. That is, from life to death, citing Apprendi at 494. The defense was asked by this court to address this question in their final sentencing memoranda. Quote, where in Hearst, Ring, or Apprendi does it say that a guilt phase finding by the jury is not sufficient to make the defendant eligible for the death penalty? The jury has made this finding beyond a reasonable doubt, not the court. Does this finding by the jury then comply with Hearst, Ring, and Apprendi? End quote. This court requests the defense address this question because in their post-Hearst decision sentencing memoranda filed February 12, 2016, the defense asserted on page 5, quote, it is possible that an aggravator can be proven beyond a reasonable doubt during guilt and then a juror feel it is insufficient to recommend death. Even if two aggravators were proven in the guilt phase, that factual finding is not enough, end quote. The defense answers this court's inquiry no in their final sentencing memoranda. Specifically, the defense urges, quote, under Hearst, additional fact-finding is necessary. Florida is a weighing state, citing Jennings versus McDonough, 490 Fed 3rd, 1230 and 11th Circuit Court of Appeal decision, which was a federal habeas decision in the Florida capital case, and Wolt, W-O-L-D-T versus People, 64 Pacific 3rd, 256, which was a Colorado case. In a weighing state, the trier of fact must weigh all the aggravating factors found to exist against the mitigating evidence to determine if the defendant is eligible for death. Therefore, in a weighing state like Florida, Hearst requires jury findings as to each aggravator relied on by the state, as well as findings as to whether the aggravators are sufficient to warrant death and not outweighed by the mitigators. Florida's advisory jury recommendation does not make specific factual findings with regard to the existence of mitigating or aggravating factors, citing Hearst at 622. The guilt-based findings are not sufficient, and the state can now, quoting Hearst, the state cannot now treat the jury's advisory recommendation as a necessary factual finding required by Ring, unquote. This court rejects that argument as the defense reads Hearst too broadly. The Hearst decision, simply put, only found unconstitutional the specific portion of Florida law that required the court, not the jury, to determine what aggravating factors, if any, were proven beyond a reasonable doubt that would cause someone to be potentially eligible for the death penalty. The court decided, based on Apprendi and Ring, that was the role of the jury only to make this factual determination. The Hearst court left undisturbed the rest of Florida's procedure. Likewise, nowhere in Hearst does the U.S. Supreme Court require any factual findings as to mitigation, because those factors clearly do not increase the potential sentence above the maximum sentence, as do the aggravating factors. Lastly, as the U.S. Supreme Court wrote in Hearst, quote, "Finally, we do not reach the state's assertion that any error was harmless," citing Nieder versus U.S. 527 U.S. 1, holding that the failure to submit an uncontested element of an offense to a jury may be harmless. This court normally leaves it to state courts to consider whether an error is harmless, and we see no reason to depart from that pattern here, citing Ring 536 U.S. at 609, the Hearst opinion on page 10. This court finds this procedural defect found by the Hearst court is harmless in this case, as the existence of the aggravating factors were determined by the jury, not the court, beyond a reasonable doubt in the guilt phase of the trial, and were reflected in the jury's verdict. Therefore, logic and the law make this defendant eligible for the death penalty in the unique facts of this case, because this case is entirely consistent with the Apprendi, Ring, and now the Hearst reasoning that any element or factor that exposes the defendant to an increased sentence has been found by the jury, not the court, beyond a reasonable doubt, and is reflected in the verdict form. Next, the court will examine these two remaining statutory enumerated factors and weigh the mitigating evidence in order to determine if the defendant should be sentenced to death on count one. The state, in their post-Hearst sentencing memoranda, argued two aggravating circumstances exist to support the imposition of the death sentence. First, the state alleges the defendant was previously convicted of another capital felony or felony involving the use or the threat of violence pursuant to Florida Statute 921.1415B. Second, the state alleges the victim of the capital felony was a law enforcement officer engaged in the lawful performance of his official duties pursuant to Florida Statute 921.14515J. The defense argues as mitigation the defendant's age pursuant to Florida Statute 921.1416G and a number of mitigation factors under Florida Statute 921.1416H. Specifically, the defense alleges, in the order they were presented in their sentencing memoranda, hereditary predisposition to substance abuse and dependence, generational family dysfunction and distress, prenatal cocaine exposure, single mother, ambiguous paternity, father absent, father criminality and imprisonment, emotional and supervisory neglect by the mother, physical and emotional abuse, observed domestic violence, the mother and boyfriend, frequent school changes, residential instability by age 8, sequential stepfather figures, corruptive male role models in the extended family, murder of maternal first cousin Rajon, community racism, corruptive community violence, police profiling, harassment and violence, inconsistent school performance, marijuana dependence from age 15, marginal youth-adult adjustment. The defendant is a devoted, loving son. The defendant is a loving father. He is a giver and selfless. He has a good sense of humor and was a silly kid, funny and memorable. He is pleasant, likable, a nice kid and polite. He graduated from high school. He earned his Associate of Arts degree. He has artistic and creative abilities. He has the love and affection of his family and positive adult relationships with his family. He has matured since this incident. He attended church and was a spiritual person. The defendant had a good employment record. He has potential for rehabilitation and positive prison adjustment. He has conducted himself well in jail. He will adjust well to life in prison, and his history does not indicate future dangerousness. He demonstrates high potential for rehabilitation. He demonstrated good behavior during his trial. He would be a positive contributor to prison. He was cooperative in his interview with the police. He admitted to the shooting. He has no juvenile criminal history, and he had no violent criminal history before February 28, 2013. This court will examine the state's two aggravating factors, first in the order listed above, then we'll discuss the defendant's statutory and non-statutory mitigation. In considering the evaluation of these factors, This court has considered the language in, among others, Campbell v. State, 571 Southern 2nd, 415, Ford v. State, 802 Southern 2nd, 1121, Treese v. State, 768 Southern 2nd, 1050, Bowles v. State, 804 Southern 2nd, 1173, Nybert v. State, 574 Southern 2nd, 1059, and Farrell v. State, 653 Southern 2nd, 367. In addition, this court recognizes that the state must prove the statutory aggravating factors beyond a reasonable doubt, and has indeed done so as found by the jury's verdict in the guilt phase. Card v. State, 453 Southern 2nd, 17, Johnson v. State, 438 Southern 2nd, 774, Williams v. State, 386 Southern 2nd, 538, Alfred v. State, 307 Southern 2nd, 433, Parker v. State, 873 Southern 2nd, 270, and that the defense mitigating circumstances must be reasonably convincing and or established by a greater weight of the evidence, Ford, Nybert, and Reynolds v. State, 934 Southern 2nd, 1159. The first mitigating factor, that the defendant was previously convicted of another capital felony or a felony involving the use or threat of violence to the person in violation of, pursuant to Florida Statute 921.1415B. The jury found the defendant guilty beyond a reasonable doubt of aggravated assault on a law enforcement officer, that is, Deputy Sheriff Clarence Bennett, as alleged in Count 2 of the indictment. This conviction involved the use of a firearm that was in the actual possession of the defendant. As the evidence at trial revealed, this act occurred just as Deputy Bennett arrived as a backup officer as the defendant was shooting and killing Sergeant Morales. Eyewitnesses testified at the trial that the defendant raised his arm and pointed his loaded firearm at Deputy Bennett. Indeed, Deputy Bennett testified that the defendant pointed his loaded firearm at him in an attempt to acquire him as a target. Deputy Bennett then engaged the defendant and shot at the defendant. If two or more victims are involved and a violent crime occurred against a separate victim, a contemporaneous conviction can be used. King v. State, 390 Southern 2nd, 315, Pardo v. State, 563 Southern 2nd, 77, Stein v. State, 632 Southern 2nd, 1361, Francis v. State, 808 Southern 2nd, 110, Wasco v. State, 505 Southern 2nd, 1314, Lucas v. State, 376 Southern 2nd, 1149, LaCroix v. State, 533 Southern 2nd, 750. Compare, for example, Donaldson v. State, 722 Southern 2nd, 177, where this aggravator generally requires a prior conviction. Holton v. State, 573 Southern 2nd, 284, Bruno v. State, 574 Southern 2nd, 76, and Elledge v. State, 434 Southern 2nd, 613, where the court held a contemporaneous conviction for a violent crime against the same victim cannot be used to support this circumstance. In Simmons v. State, 934 Southern 2nd, 1100, the Florida Supreme Court found aggravated assault on a law enforcement officer is a felony offense that involves the use or threat of violence to the person. The defense argues this court should not consider this aggravator as being sufficiently proven. Specifically, the defense in their original sentencing memoranda claims there were contradictions in the testimony surrounding this offense. It lasted less than 2 minutes. Deputy Bennett did not know whether Sergeant Morales was injured at the time the defendant was running away. At the time, Deputy Bennett fired his weapon. Further, the defense argues the evidence revealed the defendant never fired his firearm at Deputy Bennett. This prior conviction for a violent felony is a strong aggravator. The death sentence has been upheld when this aggravator is the only one present in pre-Hearst cases. Farrell v. State, 680 Southern 2nd, 390. Duncan v. State, 619 Southern 2nd, 279. This aggravator is among, quote, the most weighty in Florida sentencing calculus, unquote, Siricki v. State, 825 Southern 2nd, 882. Therefore, because the jury found this aggravating circumstance proven beyond a reasonable doubt, and the jury's verdict of guilty was supported by competent, substantial evidence, this court finds this aggravating factor exists because of the jury's verdict in the guilt phase. Melendez v. State, 498 Southern 2nd, 1258. This court gives this aggravator great weight. Second, the victim of the capital felony was a law enforcement officer engaged in the lawful performance of his legal duties pursuant to Florida Statute 921.1415J. The jury found, beyond a reasonable doubt, the state proved the defendant knew Gary Morales was a law enforcement officer engaged in the lawful performance of his legal duty pursuant to the definition in Florida Statute 943.10, paragraph 1. See the court's jury instruction, and this finding was reflected in the verdict. Therefore, this court finds this aggravating factor exists. The jury's verdict was supported by competent, substantial evidence pursuant to Melendez. In summary, this court finds two statutory aggravating circumstances exist because the jury determined this in the guilt phase and was reflected in their verdict. This court finds the defendant was convicted of another capital felony involving the use or threat of violence to the person pursuant to Florida Statute 921.1415B, and the victim of the capital felony was a law enforcement officer engaged in the lawful performance of his duties pursuant to 921.1415J Florida Statute. This court assigns this aggravator great weight. Next, the court will turn to and consider the mitigating circumstances in the order they were presented in the defense sentencing memorandum. First, the age of the defendant. The defendant was 25 years old on the date of this murder. As the defense suggests, this court must look to the evidence of the maturation if the person is over 18, pursuant to Caballero v. State 851 Southern 2nd 655 and Campbell v. State 571 Southern 2nd 415. The defense asserts the defendant's age and lack of maturity should be given considerable weight. This court finds from the evidence the defendant was a high school graduate and had earned an associate's degree. He was living in his own house with his girlfriend. They were expecting a child as the girlfriend was pregnant. He was capable of maintaining employment and was described by one former employer as dependable and conscientious. In Hearst v. State 819 Southern 2nd 689, the Florida Supreme Court said, quote, "For a court to give a non-minor defendant's age significant weight as a mitigating circumstance at sentencing phase of a capital murder case, the defendant's age must be linked with some other characteristic of the defendant or the crime, such as significant emotional immaturity or mental problems," unquote. In Campbell, 679 Southern 2nd 720, the court said that while the age of 21 chronological years is of little impact by itself, if it is linked to, quote, "some other relevant characteristic of the defendant or the crime," unquote, such as significant emotional immaturity, it can become significant mitigation. Fitzpatrick v. State 527 Southern 2nd 809. See also, for example, Garcia v. State 492 Southern 2nd 360, Mason v. State 438 Southern 2nd 374, Peak v. State 395 Southern 2nd 492, and Thompson v. State 648 Southern 2nd 692. This court finds no sufficient nexus has been established by the defense between the defendant's age and this homicide. This court gives this mitigating factor very little weight. Under family background, transgenerational hereditary predisposition to substance abuse and dependence, the defense asserts this defendant's family history includes several members that suffered from drug and alcohol dependence, including his mother, uncle, and cousins. The defendant's mother testified she used cocaine for a short period while she was pregnant with the defendant. She testified it caused him some problems shortly after his birth. There was no evidence presented this drug use by his mother affected him negatively in any way throughout the rest of his life. There was no evidence presented his mother ever suffered from any significant drug or alcohol dependence. Indeed, there was no evidence presented that the defendant was under the influence of drugs or alcohol on the day of this murder. This court assigns this very little weight. Under generational family dysfunction and distress, the defense asserts the defendant's family history includes several generations of broken homes. Most of his mother's relatives died relatively young, and several of his family members have been incarcerated. Further, because of this, he was predisposed through heredity, but also through familial behavior patterns affected him through scripts and modeling, which caused sequential damage. There was scant, if any, evidence of this presented by the defense. This court assigns very little weight to this. Under neurodevelopmental prenatal cocaine exposure, the defense asserts because the defendant's mother's cocaine use during her pregnancy, he suffered from tremors and would cry uncontrollably. The defense suggests this court give this great weight. As referenced earlier, the defendant's mother candidly testified she used cocaine for a period of time while she was pregnant. After the defendant's birth, she testified he had tremors, presumably caused by the cocaine, but she never testified of any lasting effects her prenatal cocaine use had on her son, Neither did anyone else, either a family member or an expert witness, testify about this. There was no testimony as to how, if at all, this exposure to prenatal cocaine was relevant to the defendant's actions on the day in question. As there was no evidence the mother used cocaine during her pregnancy, this court finds this factor as established, but assigns it very little weight. Under family and parenting, single-parent mother, the evidence did establish this factor. The defendant was raised by his mother and her family. His biological father was never part of his life. However, this court finds the defendant's mother was an excellent mother for her son given her circumstances. Her sisters and family also did their best to provide for the defendant. Certainly his mother worked hard over the years, but despite the defendant's allegations that he did not have a stable caregiver, there was no evidence he did not have a stable caregiver as he grew up. Although there was evidence his mother was a single parent, this court assigns this very little weight. Under ambiguous paternity, there was evidence from his mother that there was a man the defendant thought was his father. A paternity test determined this man was not, in fact, his father. This man left the family and the defendant and never saw him again. This court finds this factor has been established. However, very little weight is assigned to it, as there was no showing how this ultimately affected his life or how it mitigates the potential punishment in this case. Father's absence. As discussed earlier, this factor was established by the evidence. Although there was evidence the defendant had other adult male figures in his life, he never knew his real father, who was never in his life. This court gives this moderate weight. Father's criminality and imprisonment. There was evidence the defendant's father was incarcerated for robberies and died in prison. The defendant asked this court to give this factor some weight. However, the defense does not in any way explain how this affected the defendant's life in any way. This court therefore assigns this almost no weight. Emotional and supervisory neglect by the mother. The defense asserts here that the defendant was an only child and had no siblings to rely on emotionally and was often left unsupervised by his mother, who came home exhausted after work. At times, he lived with his aunt, who also worked, had her own children, and had to deal with a drug-dependent husband. The evidence presented at trial in the Spencer hearing does not support this assertion. The evidence shows the defendant's mother and his aunts were very involved in the defendant's life, loved him, and cared for him. Nobody in his family neglected him emotionally or physically abused him. His mother was very protective and supportive of him all his life, and remains so today. As this factor has not been proven by the defense, the court assigns it no weight. Under physical and emotional abuse, the defense alleges the men in his mother's life were abusive to the defendant and identify Lionel, who made the defendant strip down to his underwear and stand in an open doorway as punishment. The defense further alleges another boyfriend, Johnny, would leave welts on him after punishing him with a belt. They allege his mother would also sometimes use a belt to discipline him. There was no testimony presented about one of the defendant's mother's boyfriends punishing the defendant by making him stand. There was testimony presented about one of the defendant's mother's boyfriends punishing the defendant by making him stand in the doorway in his underwear. So this court finds this proven. The evidence further revealed this incident only occurred one time, and the mother removed Lionel from the home immediately after this. This court assigns this very little weight, as it was a very isolated event in the defendant's life. As far as the other allegation regarding the abuse by Johnny, this was not proven by the evidence. Consequently, this is not assigned any weight. At times, the mother may have used corporal punishment on the defendant. The court finds this to be established by the defense. On the other hand, it was never remotely abusive or excessive in any manner or way. There was no evidence that any of these very isolated instances traumatized the defendant in any respect. This factor is given almost no weight. Observed domestic violence of the mother and boyfriend. There was some evidence of this presented by the defense. The court will find it proven. But these incidents were very infrequent, and the defendant's mother would terminate the relationship immediately and remove the person from the home. Because these incidents were very rare and isolated, this court assigns this factor little weight. Frequent school changes, grades 7 through 12. The defense did establish the defendant attended several different schools during his elementary and high school years. His school transcripts and records were admitted into evidence, and this court considered them. As a result of attending these several schools, the defense asserts that changes in schools blocked the formation of relationships that might have mitigated the limitation of his parenting, thus concentrating these pathological family forces. Transitions to different schools may constitute a significant stress and coping challenge. With recurrent transitions, school rather than a place of predictability, structure, and familiarity, is unpredictable, unfamiliar, and of uncertain structure. The defense offers no evidence to support this claim or what effect this had on the defendant. This court therefore assigns very little weight to this factor, as most of it is speculation. Residential instability. There was evidence presented by the defense that the defendant and his mother moved from New Jersey when he was very young, lived with his aunt for a short time, then relocated to an apartment in West Palm Beach. By age 8, the defendant and his mother moved to Jupiter. The defendant's mother described their different residences. There was no evidence these residences were not clean, comfortable, and very adequate for their needs. Again, there was no evidence as to how this adversely affected the defendant. This court assigns this very little weight to this factor. Sequential stepfather figures. The defense established 2 stepfather figures lived with he and his mother, and these men did not stay long. Because of this, the defense alleges none of these men made any emotional connection with the defendant. This court assigns very little weight to this factor, and there was no showing as to how, if at all, this affected the defendant. Corruptive male role models in the extended family. The defense established the defendant had very few male role models in his life, and that some of them, that is, uncles and cousins specifically, used marijuana and alcohol. The defense established the defendant and some members of his extended family had negative feelings for and were distrustful of law enforcement. There was no evidence presented that Uncle Bill was a heroin addict. This factor is given very little weight. Murder of a maternal first cousin, Rajon. In the previous factor above, the defense wrote the only other male role model in Erise's life was his cousin, Rajon. 20 years his senior, Rajon suffered with drug addiction. Rajon was also a convicted felon who had run-ins with the police and shared his radical ideas with the young Eriese. Compare that language with what is alleged in this factor. Quote, Rajon was 20 years older than Eriese, and despite drug problems and being a convicted felon, he took a special interest in Eriese, who was close in age to his own son, Ahmed. Rajon's death was very difficult on the whole family, having happened the week after the unexpected death of their Uncle Bill. The family all agree that Eriese took Rajon's death very hard. He became severely depressed and closed up from them, unquote. On the one hand, the defense argues the defendant's exposure to Rajon was an example of a corrupt male role model, but on the other hand, in this factor, the defense argues this drug-addicted convicted felon's special interest in the defendant and subsequent murder is also mitigating in nature. The defense did establish the defendant's uncle did pass away unexpectedly, and a week later his cousin was murdered. The court assigns very little weight to the death of Uncle Bill and moderate weight to the murder of the defendant's cousin. Under community and community racism, the defendant claims as a young black man in America, the defendant faced racism and was exposed to racism at a very young age. Further, it is alleged he was isolated as a minority and bussed away from his home and community school, and Dr. Gabarino's testimony is cited as proof. There were never any specific examples of the defendant's exposure to any racism or racist acts or words. There was no evidence presented he was isolated as a minority. Therefore, this court gives this factor almost no weight. See Lebreu, L-E-B-R-E-U, versus State 799 Southern 2nd 997. Corruptive community. The defense asserts the defendant's neighborhood in Jupiter, Florida was a low-income housing community, was small, suffered from high crime, violence, and drugs. And although the defendant participated in some school activities, he was not an athlete and did not have the support to do other activities, spent time alone, and the adults there gave drugs to the kids in the neighborhood. There's very little evidence to support this. According to the defendant's mother, Limestone Creek was a nice community that was quiet, safe, and generally undeveloped when they first moved in. Only several years later did the area begin to deteriorate. There was no evidence presented the adults gave drugs to kids there, and no evidence the defendant was exposed to it or was given drugs there. As there was very little evidence to support this, this court will assign very little weight to this factor. Community violence. The defense presented some evidence of this through Dr. Gabarino. However, there was very little, if any, evidence presented that supported the defense allegations that this was a high-crime area where drug dealers hang out on the corners and violence was a daily experience. This factor is given minimal weight. Police profiling, harassment, and violence. This evidence established the defendant had several encounters with law enforcement as an adult in Palm Beach and St. Lucie counties. The facts and circumstances of these are part of the record in this case. There was no evidence to support the allegations that he was harassed or stereotyped by the police because his hair was in dreads. Consequently, very little weight is assigned to this factor. Under disturbed trajectory, inconsistent school performance. The defense alleges the defendant's school records show he had poor grades and passed the 5th grade were mostly D's and F's, repeated the 10th grade and was later expelled and had to complete his high school diploma at an alternative school. Ultimately, however, he did obtain his diploma and earn an associate's degree. As his grades and school records are in evidence, this court finds this proven, but because the court finds this to be of little value in mitigation, it is given very little weight. Marijuana dependence from age 15. The state agrees in their response that the defendant has a history of marijuana use, and because there was evidence of this, the court will find this factor has been established. However, as the state correctly points out, on the day of this murder, there was no evidence the defendant had used marijuana or alcohol. This factor is given very little weight, as there is no evidence of drug or alcohol use on the day in question. Marginal young adult adjustment. The defense summarizes all the preceding factors in this portion of their memoranda and summarizes the defendant's life status at the time of this murder. The defense describes how the defendant and his mother faced some difficulties during their lives. These include a fatherless home, financial difficulties, schooling issues, drug use, run-ins with the police and courts, and the loss of family members. However, there were many positives. He had a loving, hard-working mother who did her best to care for him as he grew up. He had aunts and other family members who helped out the family when it was needed. The defendant and his mother had comfortable homes. The defendant graduated high school, earned an associate's degree, had employable skills, had a girlfriend who was expecting their first child. He had his own place to live. On balance, the court gives these factors very little weight. The defendant has many positive qualities. The defendant is a devoted, loving son. This certainly was established by the evidence, as the state properly concedes. This is given moderate weight. The defendant is a loving father. There was some evidence of this, as the defense points out, that this consisted of a video of the defendant interacting with his 2-year-old son at a jail visitation. This is given very little weight, as the defendant's girlfriend was 8 months pregnant when the defendant committed this murder. Giver and selfless. Although this quality is hard to quantify, there was some testimony about this, and this court will accept it as proven. The court assigns this almost no weight. That Eriese has a good sense of humor, is a silly kid, funny, and memorable. There was testimony from at least one of the defendant's teachers and family that described the defendant as having these qualities. This is given almost no weight. Pleasant, likable, nice kid, Eriese was polite. There was testimony also from his former employers and teachers that the defendant was pleasant, likable, and polite. This court finds this mitigating factor proven, but assigns it very little weight. Eriese had graduated from high school. This also was established from the evidence. This court gives this moderate weight. Eriese has earned his Associates of Arts degree. This was established by the evidence, as the state properly concedes. This degree is from Lincoln Technical Academy for Architectural Drawing. This court assigns this moderate weight. Eriese has artistic and creative abilities. The court also finds the defendant has these qualities, as the state properly concedes from the testimony. These qualities are given very little weight. He has the love of his family and positive adult relationships with the family. This factor was established by the evidence, as the state concedes. This is assigned very little weight. Maturity. There was some evidence of maturity since this murder, that he has a different perspective on life and wishes he could take back that day in February. This is given almost no weight by the court. Eriese attended church and was spiritual. This was also established from testimony by friends and family. It is given very little weight by this court. Employment background. Eriese had a good employment record. This factor has been established by the defense and described in the defense sentencing memoranda. It is given moderate weight by this court. Potential for rehabilitation and positive prison adjustment. Eriese has good jail conduct. Although there were some minor issues with the jail staff, this court finds this has been sufficiently proven by the defense while this case was pending trial. There was no evidence about his stay in other jails that the defense mentions. This is assigned very little weight. Will adjust to life in prison. His history does not indicate future dangerousness. This court will agree that there was sufficient evidence to establish this through the testimony of Dr. Cunningham and his research. However, it is assigned very little weight. Eriese demonstrates high potential for rehabilitation. This factor is also very hard to measure, of course. This court agrees with the defense comments that the evidence establishes he had the ability to obtain adequate grades and test scores in school, jobs that involve trust, has strong and positive family relationships, has artistic skills, and has had no significant problems while in jail. However, these intangibles are given little weight. Eriese would be a positive contributor to prison. This court agrees there was some testimony from the witnesses consistent with what the defense outlines in their memoranda. This factor, however, is given almost no weight. Eriese was cooperative in his police interview. Certainly, the video recording of the defendant's statement to the police is part of the record in this case. It was the subject of an extensive hearing pursuant to a motion to suppress filed by the defense. Of course, this court carefully considered the defendant's statement and his demeanor in deciding how to rule on the motion. Despite the defense contention contained in the motion, this court found the defendant freely and voluntarily waived his Fifth Amendment rights and spoke to law enforcement. The reason for the court's ruling are contained in the order denying the motion to suppress and need not be repeated here. Now the defense asserts he cooperated with the police. In this court's view, simply giving an interview to the police doesn't necessarily equate with cooperation. It is the content of the statement that is determinative. Therefore, this court finds the defendant did give a voluntary statement to the police and was captured after a car chase from the murder scene. But it has not been proven he was, quote, cooperative with the police, unquote, in what he said in that statement. Since this has not been proven, this is given no weight by the court. Eriese admitted to the shooting. As referenced in the preceding paragraph, the defendant gave a statement to the police about his actions in this murder. Yes, he, quote, admitted to the shooting, unquote. But his version as to why certainly did not match the overwhelming evidence of his guilt in this case that was produced by the state at the guilt phase of the trial. His statements proved to be untruthful and self-serving. This has not been proven in any way in the way the defense portrays it. The defendant didn't confess he committed murder. In essence, he claimed shot Sergeant Morales in self-defense. Consequently, although the defendant admitted to the shooting in the strictest sense, this court finds this factor not proven as the defense intended. It is assigned no weight. Eriese has no juvenile history. This court agrees there was no evidence presented that the defendant had any juvenile criminal history. That the defense cites this as mitigation, notwithstanding the assertions about the defendant's poor upbringing, is ironic. This court assigns this moderate weight. Eriese had no violent criminal history before February 28, 2013. As the state properly concedes this point, and this court finds from the evidence presented this factor to be true, this court concludes this to be proven. This is assigned moderate weight. Now, Mr. Backel, do y'all have a score sheet prepared?
No, I don't. I can supplement one.
Well, I need one at the time sentencing's imposed, so I'll give you a minute if y'all want to prepare one.
Okay.
I'll step off for a minute. If y'all want to prepare one, let me know, because the rule requires I be presented with one.
Yeah, all right, I'm sorry about that.
Okay.
Told Mr. Hendricks to do that.
Mr. Hendricks has been properly trained in my courtroom, Mr. Backenall.
I know that.
Okay, we'll just go off the record. I'll step off. Nobody needs to get up. If they'll let me know when that's finished and show it to the defense, please. Okay.
Now I'm like, that's why
Are you just getting off work? Oh.
Yeah.
What you got with me? Make me some plantains or something? Or some pork? Where's that?
Thank you all very much. Tisdale's present, all council are present. Thank you all for bearing with me. Saldonio, does the defense have any objection to his score sheet?
No, Your Honor.
Before I pronounce sentence, I just want to make sure if any minimum mandatory sentence applies on count 2, or count 1 for that matter.
Yeah, I thought we had a actual possession interrogatory on the verdict form, so
Let me
just should probably confirm that.
Let me double check. Print the verdict form.
There's an actual possession,
Which would require it, yeah, please.
3 years.
On counts 2.
And there'd be a minimum mandatory on the aggravated assault as well, which is actual possession. That's also,
Also a 3-year. All right, just one other thing or two before we conclude. I'm going to file the, excuse me, original sentencing order with the clerk as I'm required to. I've got copies for each of you all. I've noticed a couple of typographical errors in here as I went along, so if y'all don't mind, I may just file a simple amended sentencing order to correct some spelling and Scrivener's errors prior to an appeal being filed. State have any objection to file an amended one correcting some typographical errors that I've noticed?
do I have an objection?
Yes.
No.
Defense? I'm going to file this one that I just read with the clerk here shortly, and y'all will be given copies here as soon as I'm done, please. All right, Mr. Tisdale, if you could step up to the podium here, please, for pronouncement of sentence. In carefully weighing the aggravating factors that were established by the state beyond a reasonable doubt against the mitigating factors established by the defense, it is not simply a quantitative analysis, but is a qualitative one. It is this court's duty to look both at the quality and the nature of the aggravating and mitigating circumstances which have been established. Under such an analysis, and upon reflection and consideration, the proven aggravating factors substantially outweigh the mitigating statutory and non-statutory mitigating factors. Therefore, Eriese Alfonso Tisdale, as to count 1 of the indictment, first-degree murder of a law enforcement officer with a firearm in the lawful execution of his legal duties, it is the sentence of this court and the judgment of the law that you be sentenced to death for the first-degree murder of Sergeant Gary Morales. As to count 2 of the indictment, aggravated assault on a law enforcement officer while in possession of a firearm, the court sentenced you to serve 15 years in the Department of Corrections. I am required to impose a 3-year minimum mandatory sentence as required by Florida law. As to count 3, will adjudicate you guilty of possession of firearm by a convicted felon. Sentence you to serve 15 years in the Department of Corrections to run consecutive to the sentence imposed on counts 1 and 2. You'll also be given, I'm also required to impose a 3-year minimum mandatory sentence on that offense. As to count 4 of the indictment, fleeing and eluding, the court adjudicates you guilty, sentence you to serve 5 years in prison to run consecutive to the sentences imposed on counts 1, 2, and 3. You'll be given credit for 1,156 days served by you on that sentence up until today. I'll assess the statutory required court costs, $100 cost of prosecution, and the public defender costs as made reference to earlier without any further court hearing. It is further ordered that you, Eriese Alfonso Tisdale, be taken by the Sheriff of St. Lucie County to the Florida State Prison and there be kept in close and secure confinement until the date of your execution is set. It is further ordered that on such time as scheduled by the Governor of the State of Florida, at the place of execution named in the Governor's warrant of execution, you be put to death. You are hereby notified that the judgment of conviction and sentence of death are subject to automatic review by the Supreme Court of Florida. You are further advised that you have the right to the assistance of counsel in filing and preparation of your appeal. If you wish to have counsel appointed for your preparation of your appeal, you may advise the court through your lawyer, and then counsel will be appointed on your behalf. You have 30 days, sir, to file an appeal. If you're unable to afford a lawyer, one will be appointed to represent you. Thank you, sir. That's all.
Well, it's all good. I'm home. God got the last say so.
Thank you all very much for being in recess. Thank you for bearing with me.